I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP 90. Yes, number 90 is the compilation video that we're getting ready to jump into. We're going to be in 3 different judges' courtrooms on today. As always, there will be no commentary added to this compilation. Chapters will be added for your convenience. Don't forget to like, share, comment, subscribe, all of the things you've been doing. I just want to say thank you and I appreciate it. Now, the judges' courtrooms that we're going to be in on today. First, we're going to be in the courtroom of Judge Phyllis Webster out of the state of Kansas. Second, we will be in the courtroom of Judge Erane Washington out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Shawn Perkins, also out of the state of Michigan. Guys, we are on our way, as you guys been saying in the comments, on our way to number 100 when it comes to these compilations. We're getting some things prepared, more videos, more content that some of you guys may have never seen. And we're, even whether it's new or old, I'm starting to just add them into the compilations, because to me, you guys are enjoying that, format a lot better than just a single format. So I want to make sure that you guys enjoy the videos that best fits how you want to see it. So that's what we're going to keep doing. Now, let me stop talking. I've talked enough. I'm holding you back from number 90. Let's go ahead and jump in.
And Judge, I am on standby on Mr. DeBus. Although I'm not attorney of record, I will be standing by though.
All right, and that's what I'm going to call now, because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBus, with Jared Regier for the state, Mr. DeBus in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBus led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand, and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBus, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the state of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issue or trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay. So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not what I keep handy, but giving a short recess, I can find that.
Well, now, before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest for
well, we're not going on
22-2401.
We're not going down that path right now, sir. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pre-trial will be September 30th, 2024. Do you have any objections to that?
No objections.
And Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas.
3FB 1548.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Glenn Milhan. Could you state your name for the record, Glenn?
My name is Glenn Milhan.
Thank you. Good morning, sir. All right, we're here for sentencing in this matter. Have you had a chance to review this report with your client?
I did, Your Honor. We went over it together.
All right. Any corrections, additions, or deletions to the report?
No, Your Honor. We would ask the court follow the recommendation from probation with just one caveat. Mr. Milhan did indicate to me that he would like to be able to use marijuana, and he doesn't currently have a medical card, so I did advise him we may have to submit a little more information. Well, he may have to get the card first, and then we might have to submit a letter. He did tell me that he uses it mostly for appetite. He has a lot of issues with that, being able to eat. So without using medical marijuana for that purpose, he would require other medication. as far as I know, he's on different medications for his mental health. And I think there's often could be, you know, issues with taking those different medications, and he's had really some adverse symptoms. He said using marijuana has been the one thing that really has helped him with his appetite without feeling, you know, over medicated. So that would be our only request. But other than that, we would ask the court follow the recommendation from probation.
Ms. McDuffie?
Your Honor, I don't have any issues with the recommendation. I'm just really concerned overall about Mr. Milhan, this case, his history. I don't have a good sense of, I guess I should say, where he is and what's really going on and what it's going to take to make some progress here. I was just looking at his last probation, which wasn't very long ago. I think he was discharged from that just in December. So that was also a reduced aggravated stalking charge. So this is behavior that's clearly not being curbed. And of course we want him to comply with CMH and any sort of you know, orders and meds that he needs to be on, but I don't know what is necessary to actually get behavior change here. I don't know what's been tried and what may, you know, has or hasn't worked. I don't know where he's been. You know, I just don't know. So I'm just a little bit at a loss for what needs to happen with him.
Thank you. Mr. Milhan, it is your opportunity to say what you would like to say to me. I want you to know that I reviewed this report very closely. I took a look at the text messages, and I guess you call them text messages that you were sending to this individual, as well as the threats to her father and her family and exes. I'm extremely concerned. I also, you know, took a look at the behavior you exhibited towards CMH, which is outlined in the police report. And I share the concerns that the prosecutor shares about the best way to try to get you stabilized and to keep this behavior from continuing. I also reviewed that you have concerns about always being on probation. And, you know, the bigger concern, obviously, is the behavior that gets you here, Mr. Milhan. So what would you like to say?
There's two issues I would like to address. The first being that the complaining witness came to court and got on the stand and told the judge she wanted me out. And that she wanted me out, she was not wishing to testify. Now, if I had pursued it, the charges would have ended up getting dismissed for witness unavailable because she was not wanting to testify. I took the plea bargain to get out of jail due to my last case, which I was in jail for 15 months and still at the pretrial status. And the prosecutor's office, as well as myself, have phone records that is proof that I was actually innocent of that crime and that a police report was falsely admitted. I had contacted the Attorney General, Dana Nessel, about this because there's a page 33 in my transcripts that reflect fraud upon the court. And when a fraud
Mr. Milhan, could I interrupt for just a second?
Really, excuse me. This is my issue. Now, that case continuously got brought up. In this case, if it turns out to be a void sentence, which is going to be, this is going to affect this case because I've already been prejudiced. Since it's being used against me, if it turns out it's void, then all the decisions in this case has been void as well.
All right, I'm not going to proceed with sentencing today. I need to hear from the mental health department as to what is going on with Mr. Milhan. He is clearly still not stable, and I'm very concerned.
I am very stable, Your Honor. I'm not out here causing any problems at all. I'm doing
you were causing problems, sir. That's why you're here.
Yeah, but I've been on bond and I have not caused any problems. I have demonstrated good behavior. I showed up to court. I did everything that they asked me to do.
I'm not revoking their bond. I'm requesting that someone from CMH come and give me a report. And that's what I'm going to do, sir.
All right, what do you need me to do, Your Honor?
All right. Sentencing in this case is going to be adjourned until March 11th.
I challenge the court's jurisdiction. I feel that authority is being overstepped, and I feel like the court has lost jurisdiction of it.
At 10 o'clock a.m. Sir, you're treading on thin ice here, so I would suggest that you stop talking. Okay? March 11th at 10 o'clock a.m. I'm going to do this on Zoom still with someone from CMH present so I can make a determination as to what is the best sentence here, because I'm very concerned about Mr. Milhan. He does not understand the gravity of this situation. He does not understand the nature of the court proceedings. And I'm not sure that a probation sentence is the best sentence. I'm not sure that we're fully protected from Mr. Milhan, to be honest. So I'm going to adjourn this to March 11th at 10 o'clock a.m. on Zoom still. But is this Ms. Johnson's case? All right. I'm going to ask Ms. Johnson to have someone from CMH either provide me with a report and an update or come to court to do so via Zoom. I'll see you on March 11th, sir, at 10 o'clock a.m., okay? Thank you.
What is your date of birth, Mr. Gray?
Good afternoon, Your Honor. 72 is my date of birth. I have a.
Can you say that again? Go ahead, say what you're about to say.
I have a motion before the court, Your Honor.
Let me first start. Do you need a lawyer, sir?
No, Your Honor.
City of Detroit versus Christopher Gray. State your name for the record, please.
Christopher Lamar Gray.
All right, today is the date and time set for a pretrial, and then there's warrants on the other matters. I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. And I'll recall the warrants. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. You want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else do you have to say? What else?
You deny my motion because of what, Your Honor?
Yes.
There is no real.
I deny your motion because there is a and this is criminal procedure, not civil procedure. But I denied your motion because there is an allegation here.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delicti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened. Someone has either been damaged or someone has been been, or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person. And if I hurt this person and I created the crime, then you are the third thing that you have to have is the identification of the person. You have the identification of the person, which is me, but you don't have a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay. You went to law school?
No, Your Honor, I have not.
And where did you get that? Where did you get that from? Where did you learn all that?
I've been studying for quite some time, trying to understand what's going on. I have a different perspective as to what's being said that happened. I'm understanding more the procedure that is necessary for a crime to go for them to bring a crime forward. I'm understanding that a bit more.
And where did you get that understanding?
I've done some Cornell Law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law. I just started to go back through Cornell Law, started to figure out what was going on and to understand the nature of how crimes, what a crime is, and everything else. So just a course of me searching it out.
And you're citing Cornell Law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is you have to have the corpus delicti. And that is in when you're being charged criminally.
What is a corpus delicti?
What do you mean, what is the corpus delicti?
What is your understanding of what corpus delicti is?
That is the corpus delicti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delicti, which is you saying this is what happened. This is how this person was damaged. There is no
the
person.
Officer on this day, on these dates, because I got a lot of them, said that
I object. I object. The officer works.
Don't interrupt me.
I apologize, Your Honor. I apologize, Your Honor. My apologies.
The officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in the state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talk about, corpus delicti and things like that, the court denies the motion, okay? Based on those reasons that I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My apologies, Your Honor.
How do you want to move forward? Because in my experience, someone that comes into court, as you do, you do not want to take an offer. You do not believe that you need to have plates or registration or insurance, and you just disregard all of that portion of the law. And either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to put my objection on the record. And at that point,
whatever your objection is noted. What do you want to do, sir? Do you want a trial? You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Very good. Ms. Mathis, I need a jury trial date. Please.
And if I may, Your Honor, what time is Mr. Gray presently docketed?
I don't even think it matters, but I'll tell you. I don't think it matters. He's got the newer cases and the older cases are pre-trial at 8:35. Christopher Lamar Gray, and then he had some in warrant status. I counted 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases into the record. You know what I want to ask, Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been, the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well, then that's fine. If we're following rules, then therefore, let me make sure that you as well as are following the rules, because if I don't do that, then freedoms are lost. So that is in which, that is the way that I proceed, to say, okay, well then, if we're playing cards and we play and show me yours, if this is your hand, then this is mine, and let's proceed accordingly to the law. That's it. That's my only standing is, if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
And you know something? With that being said, I would agree with you 1,000%. That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here, and the police for that matter, and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench, and in my time at practicing law as a defense attorney, I get this, they can't pull me over. I've heard the corpus delicti, first time the civil procedure has been thrown at me. But from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have again, Your Honor, what I feel is that if we are following rules, that if I have to follow the rules, and every person out there, all of these officers, everybody else has to follow the rules. So if it comes down to it, what I'm going to
hope that you do by the time you come back on the trial date, jury trial date is going to be March the 18th, 2025.
Thank you, Your Honor.
You're probably going to have an audience because everybody follows me on these cases all the time.
I understand.
All right, and I don't know if that's what you want, but we're gonna do that.
It's not that.
March the 18th, 2025. We're gonna have a final pre-trial date. Final pre-trial. This is to you, Mr. Bowman, especially the day before, on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. And the trial is going to be in person. All right. All parties must appear on final pretrial date and obviously on the trial date. Now, and what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say, I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and so I guess it's to the table we go. So
yeah, but get your game in order, because I'm just giving you a little heads up. If you come in with that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors or even all of them to have some sympathy for you, sir. I don't know.
I got a whole basis for understanding, and so yeah, if you know it.
Well, that basis that you outlined shortly today is not.
What was flawed in my what was flawed, Your Honor? What is
we
flawed
already
in
discussed it. We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delicti, they do have a corpus delicti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay. All right. Okay. Well, I guess we will have that discussion again. I appreciate it. I also want to say I recognize and honor your compassion that you sit on the bench with. I see it as you go out here and you judge our people, and so for all of that, kudos, man. That's for where you sit. I appreciate that. Thank you, sir. Appreciate it.
I appreciate
yes,
that,
sir.
Mr. Gray.
Yes, sir.
You have a
yes,
safe happy holiday season, sir. And
you as well.
Best of luck to you. I'll see you back on March the 17th, 2025 at 8:30 for a final pretrial. And let me say this, let me add to the record.
Yes, Your Honor.
If there's any motions, those motions need to be in writing.
10 days, within 10 days.
Let's put that on the record to a motion. Those motions need to be in writing. Have those motions to the court by February 14th, 2025. And the response will be February 21st, 2025. And I'll rule on those motions on the final pretrial date of 3/17/2025. Again, all parties must appear, Mr. Kaufman, all right?
I'm not threatening you. Say one more word, and that's 30 days. 30 days.